Hello and welcome to O'side De-Mystified. I'm your host, Councilmember Rick Robinson. Today we have the privilege of delving into the legal landscape of our city with none other than our esteemed City Attorney, John Mullen. As the one who oversees our municipal affairs from a legal standpoint, his role is absolutely necessary to ensure the city's adherence to the law. Let's peel back the layers of legal governance, compliance, and municipal law with City Attorney John Mullen. When we return, our deposition will begin. Stay tuned, and we'll be right back.
Hello, my name is Scott Ashton, and I'm CEO of the Oceanside Chamber of Commerce. Each month, the Chamber holds its second Tuesday coffee meeting to provide an opportunity for our members to make new connections and grow their businesses. It has been exciting to see so many new relationships building through our Chamber events. If you are a business owner looking to expand your network, I encourage you to check out our Tuesday coffee and other networking events. More information is available at oceansidechamber.com.
You vote because you care, and people should care. You should care. What's wrong with you? Why don't you care? Well, I'm not saying you don't care, but I'm saying you should. Yes, it's easy to register to vote. There's no excuse. You don't have any excuse. If you can get online, you can vote. And if you can't get online, well, there probably is no helping you at this point. Don't just watch the video. Come on. What's wrong with you? Go to ourtime.org to register to vote right now. If you didn't vote, I will probably show up at your house and give you a smack right across the ear. I'd box your ear.
We're learning today about the Recycle Smart website, greenoceanside.org. It's the place to go to learn how to recycle right in Oceanside. E-waste. Anything with a cord, like a printer, tablet, or a computer. Call Waste Management for free curbside pickup or drop it off at the local recycling center. Still have questions? We've got you covered. The city's Green Oceanside campaign is committed to sustainability in partnership with Waste Management.
Welcome back, everyone. And as promised, I brought in today one of the busiest people in the city, our City Attorney, John Mullen. Hi, John.
Hi, Rick.
Welcome, and I appreciate you taking time out of your day to come in and talk a little bit about your role as the City Attorney for the City of Oceanside.
Thanks for having me.
I always like to start a little bit talking about, in general, what the City Attorney's role is and about yourself. How did you come to be a City Attorney?
So I went to school locally, was raised in North County, and went to college at UCSD. And then I had a year of graduate school abroad and went to law school at USD. And while I was at the University of San Diego, after my second year of law school, I had the opportunity to intern in the San Diego City Attorney's office. And so I really wasn't expecting to get into government service, but I thought it was a good opportunity to see all the different aspects of being a lawyer. For example, the office had 3 different divisions. They had a criminal prosecution unit, they had a civil advisory unit, and then a civil litigation unit. And so the interns would spend 1 month in each of those divisions and just do any number of things. So like my first day as an intern, there was a big scandal that emerged in the city involving the planning director and a harassment claim against a subordinate employee that was plastered across the front page of the paper. And so the office asked me to work on aspects related to that immediately. So it was a really good sort of introduction into a lot of different varieties of the law within the 3 different divisions. It gave me exposure to a lot of different things. And so then I started thinking a little bit more seriously about maybe this would be a place for me to work. So I agreed to come back after my 3rd year of law school. Pending the bar results, I accepted a position with the office as a first-year lawyer. And all the attorneys there go straight into the criminal division and do jury trials. So my thought was I would get a bunch of jury trial experience and then maybe move on to the private sector. And so within the first year, I was able to try maybe 15 to 20 jury trials, criminal prosecution cases that the San Diego office handled. And then I was offered the chance to move into the civil litigation unit. And so I ended up sort of making a career because I was able to do a lot of high exposure land use, CEQA type cases. And I just gained more and more experience and decided sort of to make a career out of it at that point.
So as it goes from a career perspective, what have you found to be the advantage of working for city government as opposed to, or government in general, as opposed to maybe private practice or something like that?
Yeah, I think there's a couple of advantages. One is that you get to do very meaningful things at a young age. In a lot of law firms, when you're hired, you're doing a lot of grunt work, you're doing a lot of discovery, depositions, but you never really get into the courtroom to experience trials. You never argue cases before the Court of Appeal, and you never work on things that are really necessarily all that important. They may be important to your individual clients, but publicly they're not that significant. And so what really led me to decide to make a career out of this is because I got great experience in that office. I was able to work on really important things at a relatively early age. I had really good mentors. There were lawyers in the San Diego City Attorney's office. I was hired by John Witt, who was a longtime legendary city attorney. He had a lot of high-level lieutenants who were very experienced trial attorneys, and a lot of them took me under their wing, and I was able really to get great experience. That's not to say you wouldn't get that kind of experience in private firms, but I think it sort of fast-forwarded my development as an attorney. And you can also work on things that are relevant to the public at large. And so that kind of captivated my imagination at a relatively early age.
So, and the San Diego City is much bigger than Oceanside, obviously, their office, and county has county council, and which is, I think, a very similar role. And,
Sure.
And you've been now with the city for how long?
I've been with the city of Oceanside now for about 18 years. I'm just about ready to start my 19th year with Oceanside. So I spent about 12 years in the San Diego City Attorney's office. I then was recruited to go down to the city of Chula Vista for almost 2 years to help them with their general plan update. They were undergoing a lot of redevelopment. They were doing long-range planning for the eastern part of the city, for the Bayfront, for the Urban Core specific plan. And so I worked on those projects, and then the opportunity in Oceanside emerged, and I had been a lifelong resident of North County, and I thought it was too good to pass up. So,
well, let's talk about your office in general. What the City of Oceanside Attorney's Office, what's it comprised of? How many lawyers and staff do you oversee?
So we have 9 total staff in our office, 6 of whom are lawyers. We have 2 legal secretaries and a paralegal. And so the office provides, we're like kind of, Oceanside is a large municipal corporation. We're a charter city. We have about 1,000 employees. We have a large police department, fire department. We have an airport. We have a harbor. We have a lot of, aspects of city government. And so laws regulate all of those things. And so we've divided up our office into providing advisory services to all the various departments.
Right.
My assistant city attorney, Barbara Hamilton, and I advise most of the city departments. We have a senior deputy city attorney who advises the Oceanside Police Department essentially as a full-time job. I have 3 attorneys who are full-time litigators who defend the city primarily in civil cases that are filed against the city and its employees and officials. At any point in time, we may have anywhere between 17, 18, and 30 lawsuits, perhaps more sometimes, against the city at any one time. And so, we have lawyers who represent the city in court, both federal and state courts. We have cases that go to the Court of Appeal. And so there's a wide variety of legal services and, just day-to-day legal advice for the city council, the city manager, and all the departments and the employees. It's really a interesting job where you really never know what's going to come in the door the next day. There's a lot of novel legal issues that are presented on a day-to-day basis.
In my first episode of O'side De-Mystified, I kind of did an overview of city government, and I made this statement that the city, when I was talking about the city attorney's office, I said the city attorney is not the lawyer for the city council per se. You're not our legal personal lawyers, right?
I'm not your personal lawyer. I do represent the city as an entity.
Right.
And the city operates through an elected city council. So we advise the city council on legal issues affecting their decisions. We also defend the city's decisions in court. And those actions are often taken by the city council, sometimes by other commissions of the city. But we're not the individual personal lawyers of any individual elected representative. So we represent the council in its official capacity as the head body of the city.
I know I've come into your office trying to figure out what the laws might say, something, or what we've done in the past, and you advise on those kind of things.
Yeah, we have a kind of an antiquated tracking system, but it still works. So we basically review every legal document that the city enters into. And so that could be thousands of contracts, staff reports, resolutions, ordinances, joint powers agreements, memorandums of understanding, all the multitude of legal documents that the city enters into, or we have a hand in reviewing to make sure that it is legally sound.
Yeah, last month we had our city clerk, Zeb Navarro, here, and we talked about that, about their role in document preservation and how they work with the city attorney's office for public records requests. I don't know if you had any thoughts on public records requests. And
it's kind of a Herculean task to get through these Public Record Act requests. We have a software system that enters them. We have to respond to the requester within 10 days under the law. We try not to take that long, but we have up to 10 days to respond. But the city clerk gets a enormous number of requests. And for example, I'm working on one right now that asks for all emails on a particular topic. And I looked in the file right before I came over here, and there's 697 emails that are in that file that need to be reviewed for any privileges between the attorney and the client that might allow us to not produce. But
and you do a lot of that work personally? You do a lot of that review work?
The attorneys will review as requested by the city clerk's office. So to the extent that there is material that might need to be legally reviewed before, some things are just very non-controversial and don't need to be released, like a business license. But oftentimes, parties that are in litigation with us will file Public Record Act requests to get documents, and those we pay particularly close attention to.
From a perspective of a city, do we have a lot of litigation that goes on, or do we, just kind of an overall view from us to other cities?
I don't think we do. I've been with 3 total cities, and they're all of different sizes. Obviously, San Diego and Chula Vista are larger than Oceanside, but as a percentage of the number of employees, I think we have a relatively low amount of litigation. We work really hard to try and avoid unnecessary litigation. So we'll know if someone files a tort claim. Folks are required before they can file a lawsuit to file what's known as a tort claim, and we take a close look at those to determine if there's any validity to a claim. We're very proactive in our office in an attempt to avoid litigation that might have unfavorable results for the city. So we certainly will take positions to defend the actions of the mayor and the city council, but we also try and avoid things that are avoidable, if you get my understanding.
Right.
Yeah, cases where we may have liability, we try and resolve without resort to litigation.
Right. I want to talk a little bit about city council meetings per se, because I think that's where most of the public would see you as a city attorney, unless they had business with the city or something like that. But
sure.
Can you kind of walk us through a little bit about what your role is with city council at city council meetings, and maybe even talk a little bit about the things that govern the way that we run our meetings? Because sometimes it's really frustrating. It's frustrating for me as a council member sometimes, but I'm sure it is for the public as well.
So our role really starts several weeks before the council meeting. We require that all documents that are going to the council be submitted to the city attorney's office, ideally 4 weeks before that item. So we start reviewing contracts, resolutions, ordinances well in advance of those meetings. So that's the primary role, is to make sure that whatever document that is coming before you has been closely evaluated. Of course, the manager's office and their staff will be looking at items for whether or not they're good policy. That's not the role of the city attorney necessarily. We're making sure that whatever we're doing is legally defensible. So we try and help achieve the policy goals of the mayor and the council and the city manager and his staff. So that work is done in the weeks before the meeting. As we get to the meeting, we make sure that the agenda is correct. We do review the agenda. I actually generally set the closed session agenda because every meeting of the city council has both a open session and a closed session agenda.
You want to talk about that a little bit?
And in closed session, we talk about things like pending litigation. For example, at our next meeting, we have a proposed settlement of litigation, and so we'll be discussing the pros and the cons of that. We always do that in closed session, as we're allowed to under the Brown Act, because we don't want our adversaries in court to hear.
That's what I was going to say. Why do we have a closed? Because some people get, I think, upset that we have closed sessions.
Yeah. Well, the purpose of closed session is so that the city's litigators and its client, the city council, can have an honest, frank discussion without necessarily the advice being revealed publicly. We also have other closed session items. Our labor negotiation items are done in closed session, so this council can provide direction to its staff about what it's willing to support or not support in pending negotiations. We go to closed session on occasion to discuss real property transactions so that the council can give direction to its negotiators about the price and terms of payment for selling or leasing city property or maybe buying property. So those are the typical ones that we go into closed session on.
And then you report out on what...
I do.
But sometimes it's pretty limited or there's nothing to report.
Typically, if we're just getting direction about negotiation, and that is the lion's share of the cases, is that we'll get direction from the council. For example, on a real property negotiation, you may give us negotiation, the council would in closed session, but there's nothing to report when we come out, because then we have to go consummate a transaction, and every real property transaction we'll end up putting on the open session agenda so that it could be, seen in
So again, it's not we're trying to avoid transparency. It's just a matter of procedure more than anything else, so that we're not, if we're going to negotiate the price for a piece of land or something we want to buy, we don't want to put out there what our maximum payment amount might be.
Right. You don't want to undercut your own negotiations.
So we get the best deal for the city.
Exactly. And the same with labor negotiations. Right. You may state, this is what we're willing to do. We then negotiate, or our negotiators will meet with the labor groups and come to a tentative agreement. That then goes on the city council's open session agenda, and all the financial disclosures are made about what's going to cost and what's the term of the agreement, while the main components of it. So it all gets seen in the open session.
Yeah, I think that's one of those mysteries. Sometimes people wonder, well, what's the closed session about? But when we go into open session, your role in our council meetings, again, the mayor, once it starts, the mayor's in charge of the meeting. But
the mayor's the presiding officer of the meeting, but any procedural questions can be given to the city attorney to provide advice. Everybody thinks we operate under what's known as Robert's Rules of Order. And so really what we operate under are our own city council rules that are set forth in our city code in chapter 2 of our city code.
I'm glad you brought that up.
And to the extent that we have a procedural issue that arises that's not covered in our rules, then we could look at Robert's Rules to see what the appropriate resolution is. Really all those rules is just a mechanism for us to have an orderly meeting.
Decorum, right?
Decorum's one part of it, but there's a whole host of rules that are related to the efficient operation of a meeting. And so my role will vary depending upon how active the city council wants me to be, frankly. Again, I emphasize that our role starts weeks ahead of time to make sure what's coming in front of you is correct, legally defensible, complies with the law. And then during the meeting, it is to make sure we're complying with the Brown Act. So we're not taking action on items that aren't on the agenda. I mean, one of the things I'm proud about is we've never had we've only had maybe 1 or 2 Brown Act lawsuits since I've been the city attorney here. Wow. But even those, the one that I do recall that was filed was from an opponent of our hotel project down by the pier, the Seabird in Mission Pacific. Mm-hmm. And someone who doesn't live here filed a lawsuit over it, claiming that our agenda description wasn't adequate enough to alert the public. Well, if you go back and look at it, the Brown Act requires us to have a brief description of what goes on an agenda, typically not to exceed 20 words. In that case, we had a 122-word description of what we were doing or proposing to do. And so, not surprisingly, that person lost in court, and that went up to the Court of Appeal, and we prevailed in a published opinion. So we try and make sure that we comply with, we do make sure that we comply with the Brown Act, I should say. And so we don't take action on items that aren't on the agenda. That's one of the things that I'm always looking out for.
Maybe you could talk to us about the off-agenda public items. We get a number of speakers sometimes What's the difference between, well, on agenda, off agenda, but
agenda items are just that. You're proposing to take action on a specific item, and so speakers are allowed to typically have up to 3 minutes to speak on any particular item that's on the agenda. The Brown Act also allows the public to speak on off-agenda items, so those items that are not appearing on the agenda, but importantly, they have to be within the subject matter jurisdiction of the City of Oceanside. And so frequently, and this is just kind of my opinion, having been in local government for over 30 years, folks have a hard time communicating with their state and federal governments. It's not easy to go to Sacramento and participate in the governmental process there, or in Congress in Washington, D.C., but it's pretty easy to show up at your local council meeting. And so we often get folks showing up who are really not talking about items that are within the jurisdiction of the City of Oceanside, but just want to air a grievance. And so we're kind of the easiest place to get that. And so we often do get that. We get folks, on any number of, just recently, but it's not unusual that folks will come in and talk about just government generally and their dissatisfaction because we're the easiest target.
And often they're even upset with another governing body, a whole nother, might be a school district board or,
sure,
and they want us to do some action that we have no legal authority to take any action.
Right. And the key is that I think we often just err on the side of the First Amendment and let people have their 2 or 3 minutes to speak. But the council has no ability to take any action on an item that's not appearing on the agenda.
Right. And I think that frustrates people because they'll ask us a lot of times questions and I think rightfully so, the mayor will direct a staff member to meet with them and we can do those kind of things, but
Certainly.
We can't have although I think sometimes we have answered a question or...
it's okay sometimes to answer a clarifying question. The issue is you don't want to get into a deliberation on an item that's not on the agenda, because what the Brown Act really prohibits is trying to develop a collective concurrence amongst the council about something within your jurisdiction unless it's on the agenda. And so it wouldn't be fair to the other members of the public for the council to start having a discussion on a topic that doesn't appear on the agenda because they had no notice it was going to be discussed. So, you could think about, we're talking about short-term rentals a lot lately. Well, what if somebody came in to talk about short-term rentals as a non-agenda item? Nobody has noticed that it's going to be discussed, but then the body starts talking about what we should do on short-term rentals. That's just sort of one example of why that's not allowed.
And the remedy for a Brown Act, is it typically a lawsuit? Is that typically what happens? I've always wondered that when somebody says, oh, it's a Brown Act violation. Okay.
Well, the enforcement of the Brown Act starts with what's known as a cure or correct letter. So a party that alleges that there's been a violation has to send a notice to the city alleging that there's been a violation and giving the city the opportunity to cure it before they can go into court.
Okay.
And so pretty sure I think we've only had that one Brown Act lawsuit in my 18 or so years in Oceanside, and we prevailed on that.
And I think just to clarify for folks also, Brown Act violations can happen away from our city council chambers. Council could do Brown Act violations by how? What?
Yeah, essentially it's attempting to develop or to deliberate or develop a collective concurrence amongst the council about an item within your subject matter jurisdiction. So for example, let's say 3 of the council members go to a lunch and they discuss an item that might be coming before them. That would be likely a violation because you can only discuss items that are within your jurisdiction amongst a majority of the council through a noticed public meeting, not through some kind of sidebar discussion that the public has no ability to participate in.
But if 2 council members went to lunch and talked about something, that would not necessarily...
Maybe not in and of itself, but then if one of the 2 then went to have a discussion with the other one, then we get into what's known as a serial meeting. And so these are kind of tricky things. So we always advise to talk about items that are coming before you in the open session meeting.
Open session.
And I can say from my own experience, the reason that sometimes things that are before the council look a little unrehearsed is because they are.
Right.
And we could look at the recent inclusionary housing subject. We've discussed several times what the correct percentage should be for developers to reserve for low-income housing. Currently, or in the past, it's been 10%. The council gave us direction to change it to a different number. We've had a number of meetings where there's been disagreements amongst council about what the correct number should be. Right. And it's very clear those are being done in public, at a notice meeting. They weren't.
Sometimes we change our minds.
Yeah, exactly. There's more research that's done amongst members before a final vote. So I bring that up really just to talk about. I don't have an opinion about what the right number is, but just as evidence that we don't meet, behind closed doors to hash things out ahead of time.
And I think that's the important thing. And unfortunately, these conversations always go so fast, and we're really out of time. But I just wanted to thank you. And is there anything that I didn't touch on that you think is important that our public should know?
I think the question I get a lot from members of the public is, what's the difference between the city attorney and the district attorney? We often get phone calls from members of the public who want us to perform duties that are more properly performed by the district attorney. So the district attorney prosecutes all felonies in the city of Oceanside.
Okay.
They also prosecute all misdemeanors unless the misdemeanor is a violation of the Oceanside City Code. My office has the authority to prosecute misdemeanors that are a violation of the city code. So our criminal enforcement is fairly limited. It is just about the city code violations. The district attorney handles all the other things. The rest of our office is primarily civil in nature. And so we're providing legal services to the city, its elected officials, and its various employees.
Well, thank you, and I appreciate your time today. I know it's a big jump to get you out of the office and share some of your time, so I appreciate it. And folks, we'll be right back after this.
Pure Water Oceanside and other local programs diversify our water supply to create up to 4.5 million gallons a day of new, local, high-quality drinking water that is clean, safe, drought-proof, environmentally sound, and cost-effective.
You're home before sunrise, on top of the house, the kids, and our future. The smell of your cooking is our alarm clock. My Shiro's day is never done. So let's start saving a little more now so we can feel prepared for retirement. A free 3-minute online chat can give us the personalized tips we need so we can live our lives to the fullest. Visit asiaretirement.org.
Nearly 100% of children will be infected with respiratory syncytial virus by age 2. Symptoms can be like a common cold. However, it can be life-threatening. Trouble breathing or dehydration are signs of severe illness. RSV is the leading cause of hospitalization of all infants. Contact your healthcare provider if symptoms worsen. Visit lung.org/RSV to learn more.
Minds can achieve anything. We make sure they get to college. Federal student aid provides more than $150 billion in grants, loans, and work-study funds to make college possible for anyone with the mind to get there. Because if given the chance, minds will do great things. Federal Student Aid, proud sponsor of the American Mind. Learn more about money for college at studentaid.gov.
Well, with that, we conclude another revealing episode of O'side De-Mystified. I hope today's discussion has provided valuable insight into the legal aspects of our city's governance and the significant contributions made by those like City Attorney John Mullen. Your feedback is appreciated, and you can get that to me by texting 760-216-7587 or visit OsideD2.com. Remember, Oceanside is a great place to live, work, and play. Don't let it be a mystery. Until next time, I'm your host, Rick Robinson.
Go to koct.org and check out our programming schedule.